continue. It is my pleasure to move to the next panel discussion. And today we're going to have a unique opportunity to investigate how mediation evolves in Africa. And I'm really grateful to our partners, Edwards Mediation Academy. Thank you for being our reliable partner, and thanks for your support that we've been enjoying from you. I mean, not only you've been supporting our Ukrainian Academy of Mediation, but you've been providing so many different free of charge courses, the joint webinars that we were running together and will continue to in the future. So we want to sincerely thank you for this, and it is my pleasure to give the floor to Susan Edwards, who is the face of Edwards Mediation Academy and the president and the co-founder of it. She's going to be the moderator of today's panel right now. So please, Susan.
Thank you, Lisa. Can everybody hear me? So when Louisa and I first discussed putting together a panel on the development of mediation in Africa, our goal was really to reflect the richness and the diversity of experiences across the continent. As you know, Africa has 50 countries, more than 50, each with their own unique historical backdrop. But one thing that many of them share is a deep-rooted tradition of resolving conflict through dialogue, which we now call mediation. There's so much development and implementation of mediation happening across Africa right now. It's really exciting. But I want to make it clear, this panel is not intended to represent all the different amazing initiatives happening throughout the continent. It's a snapshot of 4 distinct and compelling efforts that provide valuable insights for all of us. Today, we're fortunate to be joined by 3 outstanding leaders in the mediation field. They're going to be sharing experiences from 4 different countries, each at a different stage in the development and institutionalization of mediation, but all 4 approached in uniquely local ways. So with that in mind, let me briefly introduce our panelists. You have their full bios, so I'm going to keep these introductions very short. From Rwanda, we have Bernadette Uwicyeza. Bernadette has been involved in alternative dispute resolution since 2006, starting with the World Bank, and later becoming the first Secretary General of the Kigali International Arbitration Association. She stepped down in 2015 to focus specifically on mediation in Rwanda. And since then, Bernadette has been a key leader and mover in the development and implementation of mediation at the court level and expanding into all sectors of Rwanda. Bernadette brings a strong background in law and policy to this work. Next, we have Laurian Haangala from Zambia. Laurian is an economist, a business and development consultant, and serves as vice president of the Zambian Chamber of Commerce. This background gives him a deep understanding of how conflicts affect businesses and the broader economy, especially in emerging markets. We first met Laurian during a visit to Zambia at the invitation of the judiciary and the court mediation program. One of our stops was a meeting with the chamber and other business leaders. Since then, probably 5 years ago, I think now, Laurian has become a key figure in advancing mediation in Zambia, particularly in leading implementation efforts and training the next generation of mediators. And then our third panelist is Banke Olagbegi-Oloba from Nigeria. Banke is a lawyer, a mediator, a trainer, a researcher, and now officially Dr. Banke. She recently defended her PhD dissertation on the impact of court-connected ADR on access to justice, comparing experiences in Nigeria, South Africa, and the US. We've invited Banke here today to share her insights on the development of mediation both in Nigeria and South Africa, drawing from her research and her extensive on-the-ground experience. So we have 3 panelists with 3 very different backgrounds, each bringing insights from 4 countries with unique experience in developing and implementing mediation. So here's how we'll structure the conversation. I'll ask a question and each of the panelists will respond. Then I'll move on to another question. We'll go through 4 or 5 questions like that, and then we really want to turn it over to you, to the audience. We want to hear your questions, your reactions, and the perspectives you bring to this conversation. So, for the first question, I'll start with Bernadette from Rwanda. Bernadette, can you speak to the idea that for mediation to be successful and sustainable, it needs to be grounded in the specific historical and cultural context of each country?
Thank you, Susan. Thank you to Luisa and team for inviting us to share our experience, but also to learn from others present in this forum. It's really a great pleasure and a great honor to be with you. So coming to you, Susan, I would like to start by saying that culture and historical context matters when you want to start developing mediation. I would like to give few examples from our experience here in Rwanda. Rwanda, we went through a tragedy in 1994, which is the genocide against Tutsi in Rwanda. And after the genocide, the new leadership was concerned about how to address the situation where survivors of genocide and perpetrators and their families, they have to live together in a village as neighbors. And because conventional court system could not address the problem, people were killed in the village, survivors, it was difficult to know who killed who. And then the government designed a system inspired from our culture that allowed survivors and perpetrators to sit together and discuss what happened. They create space. They built on culturally, for centuries, mediation was the way of resolving disputes, differences, disagreements. And the leaders at each level of the society had the responsibility to convene for session of dispute resolution. So this was our culture that was interrupted by the colonial rule. And after genocide, the leadership thought maybe it's a time to come back to our cultural and homegrown solution, and building on that, create a possibility of addressing this complex case of making people live together in their village, coexist at least peacefully. So the forum created a form of mediation was not an accusatory forum. It was a place when people can discuss what happened, how many people were in this village before genocide, how many people we don't see now, if they are killed or if they fled the country, and those who have been killed, how they have been killed, what happened, and maybe who was involved. And when some people were convicted of participation, would, if they show remorse, would be released and reintegrate in the community. So this was the first experience founded in our culture, and it was somehow it helps us to help that to resolve to go through a difficult moment, because 2 million cases an average were handled through this forum called Gacaca Court, and it helps us to go through a healing moment for our community, but also a possibility to restart life again. So it was the first experience, a homegrown solution inspired from the culture. Building on that, they created another experience, another scheme for civil cases, major civil cases that ordinary citizens are facing in their communities. We call them local mediators or abunzi. Until now, the scheme is operational and is somehow bringing results for our population. So for the civil cases, they are handled by elder citizens elected by other citizens at the village level. And it's also another scheme that is inspired from our cultural or homegrown solution. From that, we started from those experience inspired, institutionalized through a legislation, but inspired from a cultural background. Our government thought that now it's time to bring this system in the court. And in 2008, we have established a court mediation system, and the communication key messages that are being delivered by to create awareness are cultural based. We tell people that now judges are not there in courts. They are in court not to decide the cases, but to help people find a solution. That is why our court mediation system is somehow unique in that judges are mediating cases in court. It's a system that was designed because we thought the conventional court system has also created another culture of litigation. And it's important for citizens to hear from judges themselves that there is another solution and better solution, that is mediation. Our experience now is that ordinary citizens appreciate to come in court, not to hear from lawyers, but to sit down with judges, helping them to find a resolution. And the feedback we receive from them is that they say, we are happy that now we are coming back to our culture. And culture is important. I'm training with, I'm a trainer with Edwards Mediation Academy. And our approach to training is to hold a gathering of participants from different sectors and to take the course, the online course together to discuss how to reflect on our cultural context and to see how the skills we are learning, we can apply them in our cultural context. And now we are documenting stories, success stories and innovation and the creativities that is happening, building on the combination of modern mediation skills and best practices we're finding in our communities. So I would say that taking into account building on our roots, building on our culture, and to create a mediation system that address contemporary problem in our society. This is our approach, the approach we have adopted in our country, and always look for solutions that take into account our cultural beliefs and our cultural practices and our community initiatives. So maybe I can stop here, Susan.
Thank you. Thank you. Banke, would you like me to repeat the question, or are you good with going on?
Thank you very much, Susan. I'm very good to go on. I would say that for success and long-term sustainability, it is very, very, very important for mediation models to be designed in such a way that it would reflect the cultural context of the people and also their social norms.
I'd like to interrupt here, Banke. You're speaking about South Africa. So I just wanted to make sure that the panelists understand she's now speaking on behalf of South Africa. I apologize, I did not say that.
Okay, thank you very much. Thank you, Susan, for the clarity. Now, South Africa's the history in South Africa of colonialism and apartheid left behind a legacy of social, racial, and economic divisions. Now, during apartheid, the formal legal system was widely seen as oppressive, as inaccessible, as illegitimate by the majority of the Black population in South Africa. In contrast, many communities relied on customary and informal mechanisms to resolve disputes, rooted in the principles of restorative justice, communal dialogue, and reconciliation. Now, following the transition to democracy in 1994 in South Africa, there was a national drive to rebuild trusts, promote social cohesion, and transform the justice system. Now, this made mediation, especially when aligned with African customary values, to be an ideal tool for achieving sustainable dispute resolution. Now, drawing on Ubuntu and restorative justice. Now, one of the most profound contributions of mediation success in South Africa has been the incorporation of Ubuntu. Now, Ubuntu is an African philosophy that emphasizes human dignity, mutual respect, interconnectedness, and restorative justice. And how has this been applied in South Africa? For example, the Truth and Reconciliation Commission in South Africa is a landmark example. Chaired by Archbishop Desmond Tutu, the TRC was not a court of law, but a restorative justice process based on truth telling. You tell the truth, you tell your stories. It is rooted in forgiveness and national healing. You tell your story, but you be truthful. You forgive, and also you help parties to focus on national healing. Now, the impact has been deep. Though not mediation in the traditional sense, the TRC's process embodied in the principles of culturally grounded mediation, has helped to set the tone for the country's broader reconciliation and ADR landscape. Now, we also have in South Africa community and traditional courts. Community and traditional courts. So South Africa's recognition of customary law has allowed indigenous conflict resolution practices to flourish, particularly within the rural communities. For instance, in many communities, traditional leaders mediate disputes relating to land, family matters, and so on and so forth. And the focus would usually be on dialogue, on restitution, on restoration, on forgiveness, on healing, on communal living, on love, on how focusing on all these things that I've mentioned can help the community to thrive better, can foster strength, and help everyone to be happy. Now, these forums are seen by the people as credible, efficient, and culturally legitimate, especially people who feel alienated from formal court system. Now, let me now come to the court annexed mediation program. So in 2004, South Africa's Department of Justice launched a court annexed mediation program to expand access to justice and to make justice more affordable to the people and also less adversarial. Now, the program was designed, to train mediators. They trained mediators to both use legal and culturally sensitive approaches that would encourage amicable settlements, particularly in small claims, family matters, and civil disputes generally. The program has had great success in areas where mediators speak the local languages of the people and apply relational rather than confrontational mediation styles. And that, is very consistent with the way and norms and cultural beliefs of the people. So it helps. Now, by addressing disputes early and amicably, the program, has helped to reduce the burden on courts, though more work is being done, to maximize that impact. But then it encourages resolution ownership by the people. The people feel more involved. They take charge. They connect more with the process, and they believe that they are in charge of the process and also the outcome. So it increases compliance with mediated agreements. Mediation in land and social justice disputes. Post-apartheid South Africa, has faced land restitution and redistribution disputes. And within the context of land restitution and also redistribution, people have challenges, especially the Blacks, with access to land. And so land matters are also, largely resolved through mediation in South Africa. And because mediation on this subject matter is designed to attune culturally with the people, it has been more successful, successful, and it prevents violence, it builds consensus and preserves existing relationships. It strengthens relationship among South Africans. So it has also helped in terms of resolving labor disputes. So generally speaking, it enhances greater public trust in the process itself. It promotes higher participation and resolution rates. It promotes increased social cohesion and conflict prevention. And it has helped to sustain institutional use, especially within the communities, also within in terms of resolving labor conflicts and land matters, family disputes, as I earlier mentioned. So maybe I should just stop for now at this juncture, and then we can take it forward as we move on with the conversation. Thank you so much, Susan.
Thank you. Thank you. And now, Laurian, I'm going to ask you to speak on behalf of Zambia. Do you need me to reread the question?
In a while, so please do.
Can you speak to the idea that for mediation to be successful and sustainable, it needs to be grounded in the specific historical and cultural context of each country?
That I agree entirely, and that is because in Zambia, mediation has evolved basically along the lines of the two countries mentioned, particularly Rwanda. Every culture, as you know, has got dispute resolution mechanisms. Now, at the basic level, it will start at the village level, and so similarly, we have customary mechanisms put in place by where the traditional leaders are the ones who resolve issues. Now, basically, it is mediation that is used there. Now, much as in Rwanda and probably in South Africa, when there was under colonialism, they then decided that every form of such, dispute resolution mechanism is necessarily not exactly, up to standard, up to scratch. And so they resorted to imposing a judicial system that allows for the particular type of, dispute resolution, which is based on English law, common law, and all of that. Now, that brought a particular problem for Zambia because, yes, the court structure does begin at the customary level. So the headmen, the chiefs would handle those. And then the next formal level are the subordinate courts, beginning with the local court. Now, all these are subject to English law system. All right. So you will have to have a particular skill set and qualification to do that. Now, at the local court, I must say, yes, most of it is more inclined to mediation, but then you do have justices who dispense the justice. And then going on up, then you have your magistrates court, and then depending on the level, you have the High Court, the Appeals Court, and the Supreme Court. Now, in particularly speaking about the subject we're talking about, we had a disrupted culture in the sense that mediation was natural in our country, but when the English judicial system was brought to us, now almost everyone, you'll be very amazed at how much litigation there is in this country. I mean, only the other day I was mediating a matter where this gentleman worked for about 6 weeks, and then he had to leave, and he sued to the subordinate court, the Industrial Relations Court, for 1 month's salary. Okay, he brought a suit and we sat down in court. When we discovered it's only 1 month we're talking about, all of us were like, why didn't you just talk over this? So people in Zambia, as a result, because they do not know, they sue for almost anything and everything. Now, with that as a background, here's a challenge that we have in Zambia. Yes, we have the Ubuntu that they talked about in South Africa, basically promoting human dignity, respect for others, and shared developmental goals. But now, because of the litigious or the background of always suing people, I'm just trying to make sure that I speak English, which is easily understood by everyone. So when you have that as the background to your as a solution that everybody knows, mediation then really had to be introduced, almost like it is a new thing in this country in terms of the formal economy. So it was only about 20 years ago that now, it was put down in writing that, yes, we should have laws governing mediation. Now, I must say, and this will be good for experiences in other countries, that the mediation, the legal framework for mediation actually was born by a desire for the country to have a specific law governing alternative dispute resolution. So anything that is an alternative to the formal court system was then codified or written down in that law. Now, here's the challenge. The first consideration was for arbitration. So to this date, it's basically called the arbitration law. And then for me as a mediator, because I'm an economist, I'm not a lawyer, down there somewhere, they suddenly decided to attach mediation, and it is not a separate act. So because of that, introducing mediation in Zambia has been very difficult. So the way that it has come about was court annexed mediation, which is the first stage. And in court annexed mediation, of course, you only deal with civil cases, you don't do criminal cases, you don't do constitutional cases in Zambia. So now we do get some files coming through from a judge. So a judge will look at a matter and say, all right, so this matter can be resolved by the parties talking. So take it out of the control of the court litigation system for now, give it to the mediator, let's see how it goes. If it does work, then it is settled. If it doesn't, then it goes back to court. With that as a background, you will notice therefore that it's not very strong. Even the parties, and especially the lawyers, if the parties are represented by the lawyers, will have it in mind that, okay, let's just go through this formality and get right back to court. So it requires all the skills of a mediator to actually get the parties, and especially the lawyers, to understand, hey, this is as important, and it's critical to conflict resolution. And thanks to the very good training we've received and development of skills over the years, quite a number of our cases are resolved even by parties and lawyers who really were not for it. So in a nutshell, the cultural context in Zambia, background is basically the same, but in terms of the result, you'll see that in Rwanda, it has basically caught on from what was said, but here we're really introducing it. Last bit is to talk about the commercial mediation. Now that is where we come in. By the way, I was a former vice president, not vice president right now. So in the commercial sector, we're trying to look at private mediation. The only thing that we need to look at critically is the enforceability of the agreements that are arrived at in private. So the cultural background does matter, and Zambia is a very peculiar case, and I hope you will learn a lot more as we go along. Thank you.
Thank you. And now we're going to go back to Banke, who will talk about Nigeria.
Thank you again, Susan. And once again, I would reiterate that fitting mediation design and culture into the historical and cultural context of the people is critical for success and sustainability. Now, Nigeria have significantly advanced both in terms of sustainability and success of mediation. You know, when we look at mediation success and sustainability today, Nigeria is not where it used to be. And aligning the dispute resolution design in Nigeria with the historical and also social context of the people would be discussed, capturing the following key dimensions. First of all, historically, I would mention that Nigerians resolve disputes through traditional and customary systems. That is, traditional leaders like the kings, the monarchs, religious leaders like the pastors in the churches or the imams in the mosques. They resolve disputes among the people, even family heads. Now, similar to what you have heard about South Africa, about Zambia, you know, about Rwanda, these systems emphasizes restorative justice, communal harmony, reconciliation, forgiveness, love over punishment or adversarial outcomes. And this is not far from the fact that predominantly the traditional culture and system believes in all this. Now, practically speaking, mediation designs that have been incorporated into these elements have thrived more. So Nigeria is interesting because we have 36 states in Nigeria. So Nigeria is in is in the western part of Africa. So it's a country with over 200 million population, with 36 states, 3 major tribes, over 200 languages, and customary practices. So it's a very big country with a very diverse background. And so to reflect that, to tune into that, in each state of Nigeria, we have court annexed ADR programs with different system design, all different, there's no uniformity. Simply because we want these programs to reflect the historical background and the social context and beliefs and needs and wants of the local people, the people within each state. So historically, when the elders are resolving disputes, they adopt styles like storytelling. Face saving is very important. Saving faces, like not being judgmental, not putting people on the spot, letting them know what they have done wrongly, yet not making them feel so bad in the presence of the other person. Respect, empathy, consensus-based outcomes, you know, all these practices and values, I've seen that when we, you know, embed them into mediation, it yields better results. It gives the people that sense of belonging. They are able to connect more, you know, they feel that they are in a safe place, in a familiar setting. They are happier with the outcome, and then enforceability of the negotiated agreements are made easier. So this familiarity enhances trust and acceptance, you know, and helps the communities to engage more with mediation, and then they view the outcome, like I mentioned, from a more legitimate perspective. So when you relate mediation with the cultural background of the people, I have observed that in Nigeria, when we do that, it enhances participation. For example, during my doctoral dissertation, I conducted empirical research, qualitative research, and I investigated 6 different multi-door courthouses in Nigeria. Now, 5 of them, one of the major problems that, you know, came up across board was that we have multi-door courthouses. However, there's low patronage. We don't have as much cases as we think we should have. Referral from the judges appear to be lower than we expect. However, there's a particular multi-door courthouse in the northern part of Nigeria. So in the northern part of Nigeria, you have Muslims predominantly. In the eastern part of Nigeria and also the western part of Nigeria, you have Christians predominantly. And all these are post-colonial area. So, but at the background, you have people who are still practicing the indigenous traditional religion, herbalism, okay? Now, in the northern part, there was a particular multi-door courthouse. Now, they did not call their multi-door courthouse, they didn't tag it as, they didn't give it the name multi-door courthouse. They gave it, the name is Amicable Settlement Corridor. Amicable Settlement Corridor. Now, in that state, first of all, they have mediators who speak, while mediating, the local language of the various tribes in the state. So when you come, and then, you know, this mediation center is annexed to the court's premises, and an average person in that community, you know, is afraid of the courts, scared of litigation, afraid of the judge, because when you enter the court, you see the judge fully robed, you know, and then you see police officers in the courtroom, and then the formality is rigid, and so people are scared. But on the other hand, you enter this room, very serene, within the court premises, and you see people who you think would judge your case, quote and unquote, sitting on the mat on the floor, putting on the local attire. And when you come in, they smile, they welcome you with your local dialect. They tell you to sit down, they share kola nuts with you. They share water with you. They welcome you. They are very friendly. You have a conversation. They have a conversation with you in a very friendly and informal manner. Now, my research found that in the corridor, they have more cases. They are oversubscribed. Their own challenge at that time was that they need to expand. So that is just to cite an example of how fully aligning mediation design to fit into the people's way of life, would enhance success and sustainability. That's a typical example. Now, like I mentioned, I studied 6 different states, but in just one state where they do that fully. Now, in the other states, there's mediation ongoing in the various palaces, like in the various houses of the monarchs, of the kings, in the various religious houses, in the various non-government organizations, offices. They are all mediating, and they are incorporating the values, the norms, the beliefs, the way of life of the people into mediation. And when we do this, the success is higher. The success is higher. So going back to the question, I would say that yes, it's very important. I always preach that it's okay to adopt, but it is critical to adapt mediation design, the dispute resolution design. You adapt it to what your people want. You redesign, you upgrade to fit into the way of life of the people. By so doing, people would not they won't really push back. They would embrace more easily. They would be able to identify more easily with the dispute resolution process design, and then everyone would be happy. You achieve your goal, it will amount to a win-win for everyone. So maybe I should stop there again. And just before stopping, I would mention that even the various multi-door courthouses, because I've practiced there and I keep on practicing there. I speak Yoruba, for example. I'm from the western part of the country. And if I have parties who cannot speak English, I speak my local dialect. And usually, when they come, especially those who are entering mediation for the first time, when you welcome them in the local dialect, when you see them, you would know them. And so when you smile and then you welcome them in the local dialect, and they see that I'm not wearing the kind of formal attire that I'm putting on right now, but rather I have something like traditional, they are more relaxed, and they'll be like, oh, so you have this kind of system here, and you have more of conversation. Mm-hmm. And another thing that we are doing right now to make mediation more effective is to train the religious leaders, to train traditional rulers, to be able to have something similar to an hybrid system, so that they will be more efficient, more effective. And then the outcome, they can even go to the multi-door courthouses and have the outcome endorsed by an ADR judge. So the laws of the various multi-door courthouses allow this. You can bring settlement agreements from a recognized institution, and then it would be enforceable. So it enhances trust and more usage, sustainability, and success. Thank you so much.
Okay, thank you. Thank you, Banke. This has been fantastic. And I'm sitting here thinking about a tie that can tie all these together. And I realized it's what Louisa put for the title of this panel, through hardship to the stars. And I think this, what you three have talked about, is really, really powerful. I have another question. We probably will not get to all of our questions before we turn it over to the audience, but here's a question, and I'll start with you, Laurian. What has been the biggest challenge to implementing mediation effectively in your country? And can you identify the sources of that challenge?
Okay, thank you very much. Very important question. I touched on the aspects of it. The first and biggest challenge was the disruption of the traditional and cultural way of having mediation as a dispute resolution mechanism that really works, okay? That has been the first challenge. And the second challenge is related to that, in the sense that in this country, we have a high rate of urbanization, okay? People moving from the rural areas to the cities. And in the cities, there are no natural mechanisms for that. The communities are not structured in a way that you have a known leadership, all right? A known leadership. Whereas the rural communities would still have aspects of that. Now, bring these people into the urban setting, and all they know is, as I said, the formal system of resolving conflict, and therefore that becomes a huge problem for mediation. We cannot reintroduce the traditional way of doing it in the urban areas because they're not well structured. Second challenge has, again, evolving from that, moving into a structure where everything is formalized, trying to introduce mediation at the back end of what has already been happening. That becomes very difficult. It's sort of like saying, okay, you can actually go to court and get your dues and everything done, but if you want to, why don't you give mediation a try? Okay, so now that try becomes the second challenge. It is like an option, and it is not actually the way of resolving mediation. The third challenge I referred to again is that mediation has been an appendage of arbitration, all right? Now, in many commercial agreements, when arbitration was introduced, many agreements had an arbitration clause. Okay, now that has brought a lot of challenges because everyone has first to go to arbitration before they can go to court if they were to follow the contract strictly. Now, double-edged sword again, their problem is the arbitration, the center of arbitration or the seat of arbitration would normally be outside of the country. So that brought huge problems. So we're working on that. Now, as an appendage of arbitration, the next challenge is, all right, so should arbitration fail, why don't you try mediation? I keep on using the word try. So that is the challenge. We would like to see a situation that we're pushing for reforms that will actually reverse the order and say, okay, before any matter goes to court or arbitration, it should go to mediation. The court system does sometimes provide challenges. I mean, they provide the court annexed files, but the challenge has been that we have had to prove ourselves, okay? We are on trial. We're looked at very carefully. What is the success rate? So they look at the number of files and then the numbers that go back unresolved. And then now we have a challenge because we're having to prove ourselves. Now, to prove yourself where human beings are concerned is really very unfair because matters are real. So we do try to, some of us have become therefore settlement junkies. We really look forward to settle so that we can prove ourselves. The last challenge would be the private mediations. As I said, getting the agreements to be enforced has been a bit of a challenge. So we're fighting, though. We're getting there. The challenges do not detract, but rather they make us design mechanisms of resolving that conflict, if you put it that way. Thank you.
Thank you. Thank you. Banke, how about, could you respond from the perspective of Nigeria, please?
Thank you very much, Susan. So the challenges are similar. So I'll speak on both countries, more so that time is really of the essence. So I think I would quickly discuss like 2 or 3 big challenges. The first one being pushback by lawyers, legal practitioners. You know, when they have that misconception that mediation is tantamount, like it amounts to a decrease in revenue for lawyers. And it's a major problem, like one of the greatest problem that emanated from my doctoral research. And so from the practical perspective, how we have addressed that in Nigeria is by engaging with lawyers, attending bar association meetings. But before attending, having a conversation with bar leaders that this is what we intend to come and discuss. And then share practical examples of how disputes, how law firms, like law firms that are responsive to today's key problems are designed. That is, having a law firm that will be like a one-stop shop where you have a mediation department, arbitration department, litigation department, in addition to all other departments that you wish to have, and citing examples of how they are being run in the big law firms and also in some notable jurisdictions, for instance, in the USA, and how what you charge per hour in litigation is not different from what you will charge per hour in mediation for people who can afford it. And we encourage that when people cannot afford it, you do it pro bono. When you do it pro bono, you are marketing your business. And the possibility that people whom you do it free of charge or, you know, at a cheaper rate for, the possibility that they will tell others about what you do will be higher. And so at the long run, you get more patronage. So we also train, and we've had amazing results and testimonies. I, for one, am a legal practitioner, but I can tell you that I am making good money in sorry, I don't litigate anymore, but in mediation and arbitration. Now the focus on this platform is mediation. But personally, I love mediation, and what gives me joy is seeing two people come into the room, frowning, not wanting to talk to each other, but living as friends, smiling and hugging each other. That, for me, is where my satisfaction comes from. Now, another problem is the problem of funding, and it's a big problem in Nigeria and also in South Africa and in some other jurisdictions that I've seen. And I would advise that if you want to design court annexed mediation, particularly, have it in mind that you need to think out of the box and include it in your law that you would source for external funding beyond funding from the judiciary or the government. Because if you focus on that alone, or you have a chief judge who at that point in time do not prioritize court annexed mediation, there will be a problem. Or the government have other priorities, you know, and they do not think that at that time mediation is important, then the system, the program can even stop for like 4 years until you have another leader. But in Nigeria, something has worked in a particular state where you have like 6 different multi-door courthouses in that state, and that is stakeholders engagement. You know, first of all, the people who are driving the program, they engage with community leaders and they let them know that peace is fundamental, very important to you, right? You need to key into what we are doing. Now, as a community leader, as a traditional leader, as a monarch, as a king, all the business owners in the community will listen to you. All the companies in the community will listen to you. Let us have a stakeholders meeting, a town hall meeting. This is our community. Let us all come together, look at the problem, come up with a budget, and people should donate voluntarily. You can even donate your building, your parcel of land. You know, that has really, really, really helped. Companies in that state, they donate willingly as part of their duty, their responsibility, you know, to communal development, social cohesion. And because the traditional leaders are at the center of all this, it helps. So I always recommend it. Stakeholders mapping, effective stakeholders engagement. Then you need bar and bench collaboration. Without the bench, it will not thrive. And don't ever underestimate the lawyers as well. So it's important, to carry them along. Have constant engagements, constant discussions. This is our state, this is our country. How do we make this work? We need each other. Training, enlightenment, advocacy. Then another important thing, if you want to have that program, it's important to put in a leader, someone who will drive, who will manage that program, who, one, fully understands the program design, and two, who have the passion. Without the passion, there will be problem. It is that person who is passionate that will go extra mile when there's no funding, that would now leverage on experience and expertise and think out of the box and look for donor agencies, look for partners to collaborate with to ensure that there's funding to move the process forward. Thank you very much. Now I've spoken for South Africa and Nigeria. Thank you.
Thank you. Thank you, Banke. Bernadette, what have you seen as the biggest challenges to implementing mediation effectively in Rwanda?
Thank you. As I said initially, we have these advantages of having a cultural open mind to mediation. But at the same time, people, because they feel that if there is a problem in a community, they feel concerned, everybody is somehow a mediator. So, and it was difficult to show them that there is a gap in terms of skills. It's only because you are implementing the mediation, people are coming to training that is, oh, I was doing things wrong. Now I know how to do better, how to improve my practice. So this gap on skills and knowledge was somehow a challenge, both for community mediators, but also for lawyers. Because when lawyers do not understand mediation, in mediation, they are either too positional or just they are absent, they are not there. And they don't know how to explain to their clients that they are doing some job in mediation to be paid for. And how we are addressing this challenge is through skills, through skills development. Because when they know the role in mediation, then they feel comfortable and they can be efficient in the mediation process. So the challenge was this of because we developed this community mediation system, at the same time, after the genocide, we developed the court system, conventional court system. Then we have this education system that was based on specifically on litigation. Now what is happening is that we are introducing in high learning education curriculum on alternative dispute resolution and mediation. And then the Ministry of Justice has started to ADR clubs in schools and in a school of law, so that at the end of the initial training, lawyers are initiated to this new field of ADR and mediation.
Okay.
Thank you.
Thank you, Bernadette. I will have one more question. How important are the legal and institutional frameworks in building long-term sustainable culture of mediation. Banke, you've touched on this a little bit, but can a strong mediation culture grow without them? So let's start with Nigeria, or Banke, if you'd like to do Nigeria and South Africa together. You did a great job last time, so that's great.
Thank you so much, Susan. I would say that you cannot build something on nothing and expect it to stand. I'll take that again. You cannot build something on nothing and expect it to stand. Legal and institutional frameworks are like the bedrock for sustainability and success. So in Nigeria, we have some states that operate only on practice directives or practice direction, and also civil procedure rules of court as the basis, for, like as their operational, the legal framework, you know, that they operate upon. Meanwhile, in some other states, what the people would focus on first is to have a draft bill and then take it to the law, the legislative body, and ensure that the bill is passed into law. In these states that started with the law first, I see sustainability and I see less pushback from lawyers. But in states where the people operate, you know, simply on weak legal framework, sometimes you see lawyers suing and saying that, I mean, what's the basis of this thing that you're doing? And you don't want distractions if you really want success and sustainability. So initially, I mentioned that in South Africa, court annexed mediation was introduced in 2014. Now in 2011, first of all, they tried to introduce mandatory court annexed mediation in 2011. That did not see the light of the day on the basis that there was no legal framework to back it up. And so the Justice Department had to go back to the drawing board, you know, ensure that they have a well-passed legal framework. And then they also changed the draft rules from mandatory to voluntary mediation, voluntary court-based, court-annexed mediation. But I need to tell you that in 2021, the Department of Justice in South Africa posted on their website, and it's still there, that court-annexed mediation has been indefinitely suspended. But something interesting happened recently in a province called Gauteng in South Africa, where if you go there today and you want to file a case, there are no dates in the court, in the High Court. There are no dates. They will only give you a 2030 date, and we're in 2025. Tell me, then where's the access? So the chief judge, like the president of the High Court, thought out of the box, and what did he do? He promulgated a practice directive saying that before you come to litigation, you must first of all, you know, explore the option of mediation. And I think that is brilliant, but then they need to, you know, come up with a stronger framework, because to the best of my knowledge, that was challenged by some lawyers. And the challenge was strong, but I think they are gradually overcoming that, because they need to open the access somehow, you know. So it's fine they're addressing that. So I think that is a step in the right direction. But overall, it is important to ensure, in fact, what I tell people is that, you know, when the will is there, there will always be a way. When you want to start it, do like 2-3 things simultaneously. While you're working, you can have different committees. Let a committee work on the legal framework and also the institutional framework. These are very important. I mean, on the other hand, keep working on engagement. Engage with lawyers, engage with judges, so that when you are done with your draft bill, you have to share it with them for their input. If you don't, they'll push back at the long run. So you have to do so many things at the same time. While you're doing that, have a finance committee. Let them start thinking out of the box. Let them look inwards within the community. Who can we engage within the community? On the regional basis, who can we engage? Even internationally. At the end of the day, if you have a 6-month target, you would come up with a robust outcome, addressing the problem from different dimensions, rather than focusing first maybe on the legal framework, or maybe on the institutional framework, or maybe just starting it the way you want to start it. But from the onset, see the end from the beginning, okay? And be ready to adopt different mechanisms towards addressing this. And I always tell people that, you see, those who are just developing their design, they are blessed, they are lucky, because this is an opportunity for you to look outwards, see what is working in different jurisdictions, and then learn from what they are doing right and what they are not doing right, so that you avoid their pitfalls and learn from successes, and then bring it back home, relate it with what your people really want, because that is important. So that is what I meant when I said adopt but adapt. Adapt to the needs of the people, the historical context, and also the social context. But please don't forget the need of the people. Also, don't forget to engage with the critical stakeholders. Don't underestimate anybody. Don't overestimate anyone. As much as the judiciary is important, all stakeholders, even the companies in the community, they are important. Then the public, the people, because you need them to patronize you. So you need to involve everyone from the onset. And then when you do that, I want to believe that you achieve more success. Thank you so much.
Thank you. Thank you. Laurian, are you, I see you now. Are you able to respond? Do you want me to repeat the question?
No, I think I quite understand it. Basically, Banke has covered the many aspects of it. What I would say would be to add to that, yes, the legal framework is very important. Without the legal framework, like in our situation, you will have a challenge trying to bring mediation on board, because then you'll be saying, well, what legal basis do you have for doing what you're doing? And then the institutional framework is very important, yes, because if the court system does not appreciate mediation, then you hardly have court annexed mediation going on. And she did mention earlier in her challenges, the challenge of lawyers. I really don't like to speak about lawyers because they're very important and critical to mediation. But yes, in our country, what we did was to train them in mediation. So we trained over 100 lawyers so far in mediation directly as a result of that. The last bit, yes, for me would be that, yes, if you want to introduce mediation, then it has to be from the grassroots up, and not up, and then you try to bring it down to the level of the people. It will not work at all, because ownership of any process is very critical. So if ownership is by the people, who will ultimately be the users of the conflict resolution mechanism, then you will definitely find acceptance is very easy. Whereas if it is seen to be a governmental move, a move by the government to introduce, you'll find it challenging. We had this very interesting experience under the Institute of Mediation Excellence, which promotes mediation and also does mediation practice. We decided that we would love to go into, the rural communities and, train people in mediation. So we went to a possible funding agency, and they just said, but what kind of mediation do you want to go and train them in? So we explained what we'd learned. They said, well, I don't think it's really going to work, because you are trying to impose a system of mediation, whereas the cultural context already has something in place. So what they did was to train, basically in basic mediation, they began to train the local court system officers, and also they went to the police stations around, because they realized a lot of conflict escalates because the original persons the conflict comes to do not understand that it can actually be resolved by talking. So they went to the police stations, trained the police officers, and it worked quite well. But the experience was very good for us. We realized that you need the buy-in of the community if mediation is going to work. After all, mediation is party-driven, isn't it? Thank you.
Thank you. Thank you, Laurian. And Bernadette?
Thank you, Susan. As my colleagues, I would say that the legal and institutional framework is the key to the development of mediation, because it helps to build the trust in the mediation. What I have observed in my country, mediation is included in the national framework. We have at the national level what we call National Strategy for Transformation for 7 years. It includes mediation. And when we talk to stakeholders around, they will say, we know mediation is part of our national strategy. It's important. Secondly, we have developed a national alternative dispute resolution policy that focuses on mediation. So this policy is a roadmap to maintain, to improve, to enhance mediation. Again, because all stakeholders in all the sectors, they know that we have this national policy. It's another stone in building trust in mediation. And now people, they know under the policy, we have a certain number of laws that need to be prepared and enacted in order to really to enhance the use of mediation at all sectors of the society. So it's important because it's just people, they know they are together advancing in the same direction. So I believe really there's a legal and institutional framework is also, in addition to training, to creating local capacity, it's a foundation of a sustainable mediation system, at least in our experience. Thank you.
Okay, well, before we wrap up and I turn it over to questions from the audience, I want to give our three panelists an opportunity to offer a final thought or moreover, respond to something another panelist has said, because I think what we've seen is there's some similarities, but there's a lot of different approaches and differences. And we said in the beginning, it's based on the cultural and historical context, which is beautiful. But I do think it would be nice if you could each speak to something you found the other one said. Laurian, can I start with you? Do you have anything?
Yes, I want to refer to the compensation for court annexed mediation. Now, in this country, we have a mandated fee level, all right? And it's basically, well, we say it is, the fee is so low that we consider court annexed mediation as community service. Okay, it's barely able to cover your fuel if you have to drive there and your talk time when you talk to the parties. So I think it's important to have a fee structure that compensates the court annexed mediator. I do know that in Kenya, for instance, the government pays the mediators. Here it is the parties that are expected to pay. And sometimes I've had situations where this party is so distressed, they've been at it for so long that I just give up the fee and say, look, it's all right. You go right ahead and we'll do this. So I think compensating the mediation structure is very important. The other thing that I like that Banke talked about was the regionalized concept of mediation. It can't be one size fits all. I think that's very important to know that. And I think that has been our challenge because it has been, like I said, top down. So we just introduce mediation and say, this is the way it goes. But looking at it now, because a lot of mediation comes to the city where I live, from the outlying areas, I do realize that some of the ways I was able to have parties resolve was because I realized that, look, I need to critically look at the background, the cultural context, and have a different approach to that. So I think that would be very important. From Rwanda, I gathered that yes, and South Africa, mediation was very important to resolve the emotional backlash from what had happened in the country. I think, and we do in our training talk about emotions, but I think that it's very important to understand why emotions are that the way that it is. Countries that are in conflict of war, I mean, you gotta have a different way of resolving issues. Thank you.
Thank you. Bernadette?
Thank you, Susan. I appreciate to learn more about the Nigeria system and how really each state is trying to design its own system, mediation system, taking into account cultural considerations, cultural beliefs, and I just want to appreciate the work of Banke, what she did to gather all this information in a big country. So it's a context we are not working in here in Rwanda. We are a small country. We can have a national, a comprehensive program. It's easy, but in Nigeria, I appreciate to learn more about these aspects of contextualization. Also about South Africa, she talked about the philosophy of Ubuntu, and we have something equivalent here in Rwanda. Mediation is founded in this idea of philosophy of oneness, meaning that if I have a problem, the other person is like me, and if there is a problem, there is no longer life. So I need myself as, if I am a party, to feel that it's my duty to reestablish harmony, peace, and to come back to this oneness. And this is also the foundation of Beyond the Culture. It's a philosophy that found this mediation in our context, and it's the root of mediation in Rwanda, in the Rwandan society. Thank you.
And Banke, would you like to offer some reflections on things that Laurian and Bernadette said?
Thank you very much, Susan. Thank you for your amazing moderation of the panel. So I agree with Laurian on the thoughts that he shared on the importance of healthy remuneration for mediators in court annexed mediation. So in Nigeria, generally, court annexed mediation is free of charge for the parties. No, court ordered. When the court orders mediation, when you are in litigation and the court says go and mediate. So it's free of charge. That's the way they designed it. However, the judiciary would pay you, but what they pay you is very little, more or less like something to fuel your vehicle. And so that affected the quality of the people that would mediate. So for instance, the well-experienced would only take that when they have the time, but you don't want that. You want them when you need them. And so during my doctoral dissertation, that was when I realized that so many states are addressing that already. For instance, I saw a state where they now amended their court rules, the rules of the multi-door courthouse rules, in such a way that they would assess you and see whether you can afford it. If you can afford it, they have a scale depending on the amount in disputes. So they have a scale of what you would pay. But if they assess you and they see that you cannot afford it, there are two options. They can call their mediators, but if there's no available mediator who can volunteer to do that matter, to resolve the matter through mediation, or the pro bono basis, they have trained their staff. So you know that your staff, you know, is on salary. But I always discourage that, because during my dissertation, my doctoral dissertation, I interviewed some people who said, my mediation delayed because the staff was busy, or my mediation delayed because the staff was out of jurisdiction on official assignments, you know, or those who said, I've had mediation with independent mediators and also with staff, and I think I enjoyed more value when my matter was mediated by an independent mediator, that is someone who is not a staff of the multi-door courthouse. So we have mixed feelings in that regard. So I fully agree with Laurian. Bernadette is doing an amazing job with trainings, you know, in Rwanda, in collaboration with Edwards Academy, and I really credit her for that. Great job, Bernadette. And you know, I've once had that conversation, come and teach me how you're doing it, but that's just on the light mode. Yeah, pretty much. You mentioned something that resonates with me deeply as an academic, the fact that you take mediation trainings to high schools. It's brilliant. You take it to the universities. It's brilliant. You know, sometimes if you cannot address immediate problems, it might be easier to address future problems. So take them young, go to the roots. Let's rewrite the story. I do that a lot as well, and I also credit you for that. Now, you mentioned something that's, from my experience in Nigeria, we would not want to, well, someone like me would not want to adopt that approach. And that is the fact that, you know, when we encourage parties to mediate directly with the judges, you know, encourage them that, now lawyers are not involved. Now, there are some clients who will not they will not say anything unless their attorneys tells them to say something. There are some clients who will not move an inch unless their attorney tell them to move. What do I do in my mediation? Once I see that they are lawyers, I welcome them. I am nice, very kind, and I am going to split into private caucus. First of all, I'm going to have a private caucus with the lawyers, and I'll let them know their roles in that mediation session, and let them know that, first of all, I will use myself as an example and let them know that I am here because I value peace. I am here because of XYZ. Now, this is what mediation is all about. I know you know it. Thank you so much again for representing your clients. However, in this process, I will appreciate if you would allow me to caucus with your clients. And I'll tell them the reason why I would have private caucusing with the clients. And I'll also tell everyone. So I address it layer by layer, layer by layer. You know why? Because I know that lawyers' pushback is a major problem in my country. And so I want the lawyers to go home with the impression that indeed I have gone through it. I met a mediator who has a legal background. I went through the process. I love the process. And indeed, it is not alarming decrease in revenue for me. Now, I've had the opportunity of mediating a lot of cases where lawyers are involved. Now, when we have our last plenary, lawyers would ask me, I love this. Please, I want to train. I have never seen a lawyer who would go back and say, no, I don't want to train. Again, it will depend on your level of expertise, you know. And I know, you know, Bernadette, I mean, you know it more than I'm learning from you. But in Nigeria, again, we are discussing historical context, cultural context, social context. In Nigeria, no. I want to advise people. I don't do it, and I won't advise people to do that. But thank you so much for sharing that, and thank you so much for what you do in your country. Thank you. Thank you, Susan. Thank you.
Thank you. Thank you, all three of you. I am hoping that we have a little bit of time. I guess we don't. We don't have any time. We have come up against the clock. There are a few questions, and I know Louisa has said that we will ask the panelists to respond to them. And I believe, Louisa, I'm going to turn it over to you after saying thank you very much. This was very enjoyable. And I know I want to thank our panelists for all their phenomenal comments. I would say, I think the summary statement for today's panel would be from Banke, adopt, but adapt. And I think that's really, really well said for all of the programs that we are discussing here, not just in Africa, but in other countries as well. So thank you. And thank you, Louisa. Thank you, everybody in the audience. And we look forward to seeing your questions.